FDA approved mifepristone based on the agency's scientific judgment that the drug is safe and effective. It's maintained that judgment across 5 presidential administrations, and millions of Americans have used mifepristone to safely end their pregnancies. Respondents may not agree with that choice, but that doesn't give them Article III standing or a legal basis to upend the regulatory scheme. At the outset, respondents lack standing. They now concede they can't rely on a statistical theory of injury like the lower courts did. Instead, they have to identify a specific doctor who faces imminent harm. But their theories rest on a long chain of remote contingencies. Only an exceptionally small number of women suffer the kind of serious complications that could trigger any need for emergency treatment. It's speculative that any of those women would seek care from the 2 specific doctors who asserted conscience injuries. And even if that happened, federal conscience protections would guard against the injury the doctors face. And there's no basis to conclude that any of that would be traceable to the incremental changes that FDA made in 2016 and 2021, as opposed to the availability of mifepristone in general. Respondents' theories are too attenuated as a matter of law. The court should say so and put an end to this case. Finally, on remedy. The relief entered below would severely disrupt the federal system for developing and approving drugs, harming the agency and the pharmaceutical industry. It would also inflict grave harm on women across the nation. Rolling back FDA's changes would unnecessarily restrict access to mifepristone with no safety justification. Some women could be forced to undergo more invasive surgical abortions. Others might not be able to access the drug at all. And all of this would happen at the request of plaintiffs who have no certain injury of their own. The court should reject that profoundly inequitable result.
Okay. Is there anybody who can sue and get a judicial ruling on whether what FDA did was lawful? And maybe what they did was perfectly lawful. But shouldn't somebody be able to challenge that in court? Who, in your view? Who would have standing to bring that suit?
I think that with respect to these regulatory changes, it's hard to identify anyone who would have standing to sue, but the court has said time and again that the fact that no one would have standing doesn't provide a basis to depart from Article III principles.
But your argument here is that even if the FDA acted unlawfully, nobody can challenge that in court. And that's basically the argument you made last week, right? In the Murphy case, we shouldn't get to the question whether the White House and others violated the right to freedom of speech. We should just say, well, these plaintiffs can't bring suit, right?
We are looking at the specific respondents in this case and their theories of standing. We don't think they come within 100 miles of the kind of circumstances this court has previously identified of non-speculative harm that can create the kind of cognizable injury for forward-looking relief.
Just to confirm on the standing issue, under federal law, no doctors can be forced against their consciences to perform or assist in an abortion, correct?
Yes, we think that federal conscience protections provide broad coverage here. Just to be
So I'm worried that there is a significant mismatch in this case between the claimed injury and the remedy that's being sought. They're saying because we object to having to be forced to participate in this procedure, we're seeking an order preventing anyone from having access to these drugs at all. And I guess I'm just trying to understand how they could possibly be entitled to that given the injury that they have alleged.
In 2016 and 2021, FDA made certain changes to the labeling and use restrictions for Danco's drug Mifeprix. The decision below stops Danco from selling Mifeprix in line with that scientific judgment based on a highly attenuated claim that an unknown doctor could be called someday to an unknown emergency room after a series of decisions by third parties. No facts causally link that possible future encounter to a specific change FDA made in 2016 or 2021. Respondents' view of the Food, Drug, and Cosmetic Act is so inflexible it would upend not just Mifeprix, but virtually every drug approval and REMS modification FDA has made for decades.
That respondent doctors will be forced to manage abortion drug harm is not a bug in FDA's system, but part of its very design. Ruling against respondents on standing here would allow federal agencies to conscript non-regulated parties into violating their consciences and suffering other harm without judicial recourse.
I mean, it makes perfect sense for the individual doctors to seek an exemption. But as I understand it, they already have that. And so what they're asking for here is that in order to prevent them from possibly ever having to do these kinds of procedures, everyone else should be prevented from getting access to this medication. So why isn't that plainly overbroad scope of the remedy the end of this case?
So with respect to the premise of that question, Justice Jackson, I don't think our doctors necessarily are able to object for two reasons. One of this is the emergency nature of these procedures. As the FDA acknowledges, many women do go to the emergency room. And if we just think about what that might look like, take Dr. Francis. She's on the labor and delivery floor supervising.
I'm sorry, I don't want to hypothesize.
So there's nothing in the lower court's ruling that would impede access. I think we should all agree that if women decide to use abortion drugs, they should be safe. The FDA's removal of in-person visits removes the best opportunity for a doctor to diagnose ectopic pregnancies or life-threatening conditions. It's simply unsafe to mail drugs to dorm rooms without women having seen a doctor.
As physicians who care deeply about our patients, it is appalling that the FDA no longer requires doctors to provide in-person, ongoing care to women using high-risk drugs. These in-person doctor visits are vital to check women for ectopic pregnancies, severe bleeding, and life-threatening infections. No woman should ever be left to perform her own chemical abortion at home alone, without even one in-person exam with a doctor. Yet that is precisely what the FDA has left women to face, despite its own label stating that roughly 1 in 25 women who take these drugs will end up in the emergency room.
In approving mifepristone nearly a quarter of a century ago, and in its subsequent changes to how the use is prescribed and used, the FDA acted on an extensive body of evidence and well within its authority and in accordance with the law. Second-guessing the scientific, data-driven judgments of an independent agency is an extreme position that could inject uncertainty across American life.